The judgment that I have to explain happened in 1916 and is Donald Macpherson versus Buick Motor Company. First, I'm going to explain the facts. Second, I'm going to say the legal problem. Third, I'm going to say the rules of law. And finally, I'm going to explain you the opinion of the Court of Appeals of New York. Facts of the judgment. First, Buick Motor Company, or the defendant, is a manufacturer of cars, and it sold a car to the retail dealer, and the retail dealer resold the car to the plaintiff. Second, one day, while the plaintiff, or Donald Macpherson, was in the car, it collapsed and he was thrown out and injured. Third, this happened because one of the wheels was made of defective wood and broke into fragments. It's relevant to note that the wheel wasn't made by Buick Motor Company, it was bought from another company. Fourth, the evidence showed that defects could have been discovered by reasonable inspection, but that inspection was omitted. Fifth, Macpherson sued Buick for the personal injury suffered, and Buick said that he was not responsible for the manufacturer's negligence of the wheel. Legal problem. Does the defendant have a duty of care and vigilance to anyone other than the immediate buyer? Rules of law. To solve this case and answer the legal problem, the court used 3 rules of law. First, if the thing will be used by another people than the buyer, regardless of the contract, the manufacturer of this dangerous thing is obliged to do carefully. Second, if the nature of a thing is reasonably certain to endanger life when it is done negligently, then it is a matter of danger. And third, there must be a knowledge of danger not only possible but probable. Opinion of the court. The court said that there is no evidence that Buick knew the defect and had it voluntarily, and for this, the court said that this case can be solved with the rule of Cullen and Lien because it isn't a case of fraud, it is a case of negligence. Also, the court said that the principle used in Thomas versus Winchester is not limited to poisons, explosives, or any dangerous object, so any object done in a negligent manner was also dangerous. For all the above, they say that the nature of a car warns of probable danger if its construction is defective. That also said that the defendant knew the danger and also knew that the car would be used by another people than the buyer. The defendant was not acquitted for an inspection duty because he was responsible for the finished object. He was not at liberty to put the finished object on the market without subjecting the components to ordinary and simple tests. For all, the court said that the judgment should be affirmed with cost. And the conclusion is that a car is not a dangerous thing, but it can be if it has a weak wheel, and the defendant have a duty to discover the damage of the wheel by a reasonable inspection and the application of a reasonable evidence.